Good afternoon. One of the things that I don't like, and I'm a bit of a dog on a bone on it, is if I am wrong, I will say I'm wrong. Hi, Hank. But if I'm right, I'm a dog on a bone, and I'm not going to let it go. So this is courtlistener.com. In case you're not familiar with it, it is my dog's probably breathing right into the microphone. It is a website that basically mirrors Pacer. So the only way that you can get these things, see where it says buy on Pacer, the only way these things get uploaded is if somebody with recap in their web browser goes onto Pacer and buys it. And then when they buy it, it automatically uploads through the recap extension in your browser into Court Listener. So as you can see here, we're on the Cordova versus Hinault case. This is the case in question. And down here at ECF, thank you, Hank, at ECF 85, where are we? 85. There's an ADR certification filed by Randy Newman. We're going to download the PDF, and there it is. So this is what's filed. You can see up here at the top, this is the actual document. This is document 85. Just downloaded it. This is Cordova versus Hinault. Down here it says plaintiff is willing to participate in the court's ADR program, including mediation. So plaintiff was willing to mediate. Who is plaintiff? Well, that would be Cordova, plaintiff. Now, defendants are Hinault, O'Heary, and String of Numbers Canada Inc. And it says defendants are willing to participate in private ADR with a retained mediator. Mediator. They're willing to participate in mediation. That's a long-winded way of saying that we are willing to participate in mediation. Defendants. And it's signed by Simon Lynn. Simon Lynn is the attorney for defendants. Highlight. There we go. Jonathan Houdon, Hinault, NECA, O'Heary, and String of Numbers Canada Incorporated. So how anybody could tell me that defendants aren't willing to mediate when it says defendants are willing to participate in private, ADR stands for alternative dispute resolution, with a privately retained mediator. I mean, I don't know how anybody could read this and think that Fraud or Troll was not willing to mediate. Goes on to say, plaintiff indicated he lacks resources to participate in private mediation. Why is he saying that I can't participate in private mediation? Well, defendants are looking for a privately retained mediator. That means that they're willing to mediate. A private mediator would ensure both sides are fully engaged in the process. A mediator with experience on the internet and cross-border issues will also ensure that both sides have a reality check. So we have, I'm going to say, three possibilities. Possibility number one, is a fraud or troll in saying that he never was willing to mediate. And this is the most generous thing that I could say, is that he was never willing to engage in mediation with a caveat, and therefore he was never willing to engage in mediation. So he was never willing to engage in mediation unless they agreed to a private mediator, and they never agreed to a private mediator, therefore he was never willing to engage in mediation. Well, I would suggest to you that as generous as that is on my part to suggest that may be what he's trying to say. Apparently he made a video on me. I haven't watched it. I don't really care about his opinion of me. I absolutely do not care about his opinion of me. But even as generous as that possibility is, it is still just disingenuous to say that he wasn't willing to engage in mediation, because he was, if they could get the mediator he wanted, which again would indicate to the court and would indicate to me that he was willing to engage in mediation. There's no way of reading that without thinking to yourself, wow, he's willing to engage in mediation, they just can't agree on a mediator. It happens. It happens a lot. Number two, which is what I think it is that fraud or troll is just flat out lying. Number three is that his attorney lied, because his attorney said that the defendants are willing to participate with a privately retained mediator. So between fraud or troll and his attorney, who would I suspect was lying? And in order to figure that out, well, we have to look for incentives to lie and disincentives to prevent you from lying. Fraud or troll is pretty easy. He has a bunch of suckers. He has people who are in my comment sections telling me that I don't know shit from fuck, and I can't read this particular document like a normal human being would read it, like an attorney would read it, like a judge would read it. I can't understand how his attorney, what message his attorney was intending to convey, apparently. So these are some really fucking stupid people. But they're giving him money. And they're giving him money because they hate Randy, and or they hate DMA, and or they hate insert person here, and or maybe they just really love fat dudes from Canada. I mean, who knows? It could be the fat dude from Canada angle. I mean, everybody's got a type, and your type might be fat dudes from Canada. Maybe you just really like the taste of maple syrup between folds of fat. And you know what? I won't judge you for it. So he has a financial incentive to keep this going. He's dumb enough to think that him saying that he didn't agree to mediation on the fucking internet, where opposing counsel could get it and potentially present it to the court, suggesting that the ADR report filed by his attorney was a lie. That could cause some real fucking problems. That could cause some real fucking problems. Once again, if you're involved in litigation, don't talk about it. That's the thing, is you don't talk about it, because you're probably not as smart as you think you are, and if you're out there making videos accusing your attorney of lying, well, that could cause some problems. I'm not going to give Randy any ideas on what kind of problems that could cause, but that could cause some really serious fucking problems. So now let's look at incentives to lie and disincentives from lying for Mr. Lynn. Simon Lynn, well, he's a bar member. And so if he engages in things that are detrimental to his client, if he lies to his client, if he fails to keep his client informed, if he acts in a manner that is perverse to his client's interests, well, he could potentially face sanctions. He could also face sanctions if he lies to a court. One of the rules of professional conduct is a duty of candor. Got to be honest to the court and to the other attorney. So Simon Lynn, apparently, according to fraud or troll here, is lying not only to the court by signing his name to this document, but he also lied to Randy. Well, that's a bit of a fucking pickle, isn't it? And then there's that whole Rule 11 thing, Federal Rule of Civil Procedure 11, that says that basically you get sanctioned if you lie and sign your name to it, or file it, or pretty much have anything to do with the pleading. And here we got Simon Lynn's name on it, where his client is out on YouTube saying, no, I never agreed to mediation. But clearly it says here defendants are willing to participate in private ADR with a privately retained mediator. That's pretty fucking brutal. So Simon, if Simon lied, not only could his client fire him, but he could get sanctioned by the court, and he could potentially face sanctions from the state bar. That's a real bitch. But what does he have to gain by it? What does Simon Lynn have to gain by it? Well, I am going out on a very, very short limb, not a long limb. I'm 90+% sure that Simon Lynn is being paid hourly. What gets you paid more hourly? Going to mediation and getting it resolved quick, or going to trial and getting all that delicious, delicious trial prep time? All that time spent voir direing in a jury. All the time spent on motions in limine. That's some juicy billables right there. Those are some hours that you could put in. Those are some hours that you could put in. So if he gets this resolved at mediation, which, unless fraud or troll is being serious and he has no intent on a settlement, even if he gets a good settlement, if he has no intention of accepting a settlement, well, then I guess Simon Lynn will make some money because he gets to do the mediation and then he still gets to go to trial. But that's a long shot because, again, most cases settle. The vast majority of cases settle. So it's just absurd. It is just absolutely absurd that people are talking about this. Like, but Fraud or Troll said he didn't do it, so I'm going to trust Fraud or Troll. You're a fucking retard. You're a literal fucking retard. Fraud or Troll has every incentive to lie, or at least in his own stupid mind he has every incentive to lie. I don't know what kind of hay Randy can or will make out of this, but I'm sure there's hay to be made. Let me just say, I am sure there's hay to be made. Because fucking Fraud or Troll is retarded and he's talking about his case and he doesn't know any better. But I'm sure he's thinking that, boy howdy, if I could just keep my supporters on the dole, then, hey, I could say all this money's going to the attorney, we could settle up real quick, and then I could use that money to pay the settlement. Not a bad gig if you can get it. Having a bunch of dupes on YouTube. Not only do they give you the ad revenue from the video, but then they give you all the extra revenue from your e-begging. Then you could use all that money to pay all the legal fees and pay the judgment, pay the settlement. But I'm dumb and I'm wrong, and I apparently don't know how to read anything. So there you go. In other news, let's see. There we go. In other news, we had another bit of a banger. LVMPD strikes back. I don't care about that. So LVMPD, after winning against Chile, they decide to file a motion for attorney's fees and costs. They're entitled to they're entitled to costs, I believe, as prevailing party, and they're entitled to attorney fees because they're claiming that Chile made allegations that were clearly frivolous, right? So one of them was the groin punch. The groin punch. He alleged that Officer Sandoval punched him in the groin. The body-worn camera doesn't show Sandoval even patting him down. He was patted down by Officers Bork and Dingle. Bork patted Decastro down, and Decastro stated, "Now you just hit me in the dick." And similar comments claiming that Bork struck Decastro in the genital area for no reason. However, he didn't flinch. Blah, 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 right? So it's saying that was a frivolous one. The other one is the selective enforcement claim. Now, in order to prove selective enforcement, Chile would have had to show that similarly situated people were not arrested for what Chile did. And Chile presented absolutely no evidence, apparently, according to this, that anybody else tried to interfere with the Well, he also said that he was discriminated against because he had white lips or brown skin. But then he had to show that similarly situated individuals had approached the detained driver or interacted with at least one other individual had approached the detained driver or interacted with Decastro while he was being detained, ignored the officer command to step back, and was not arrested. Decastro could not identify a single individual who even arguably met the criteria. So they're asking for like 18 grand in attorney's fees, an additional like 8 grand for the costs. Here you can see what they were billing. So the defense counsel was billing $220 to $250 an hour, which is pretty low. But then it went up to $300 to $350 on or about August 2025. That's more of what I expected it to be, that or higher. But apparently they probably have a contract with the city, so they get all the city's business, but they charge the city a reduced rate. And then, so he normally charges $500 to $550 an hour. And, I don't see anything for the other guy, but the attorney's fees was $1835, and then costs were like 8 grand. So about 26 grand, 27 grand, give or take, is what they're looking to get a judgment for. But, be that as it may, maybe it's just on the costs attachment. Yeah, 8209. Yeah, so about 26 grand. So be that as it may, even if they get the attorney fee award, they still have the issue of trying to collect the judgment. Because remember, getting an attorney fee award is basically just like any other judgment. You still got to collect. And there's nothing preventing Chile from saying, you know what, fuck you and the horse you rode in on, I'm not paying you a dime. Well, then they have to collect. And there are various enforcement methods that they could use. I'm not familiar with the ones in Nevada, but there are various enforcement methods that they could use, and I'm not going to give Chile any ideas of what they are because I don't want him to try to do things to defeat him. But let's just say that with a reasonably savvy person, they can make collection a very difficult, arduous, time-consuming process. But who even knows if they're going to win their motion for the attorney's fees? Maybe they will, maybe they won't. Even if the judge grants some attorney's fees, judges have a lot of discretion to award lower amounts than what the attorneys were asking for. So, but it is another fun kind of fact. I don't know if me is still representing Chile in this. I think he is. It's federal. So I think he is because this is part of the whole shebang. So I guess me is going to get to defend a motion for attorney's fees and costs for free because he was probably on contingency. And I just really feel bad for Michael Me. Anyway, that's all I got for you today. Thanks for watching. Have a great day.